So when you look at the Kohberger case, in a nutshell, it's a very circumstantial case. They have some DNA, but they don't have their blood in his car. They don't have a whole lot of other things. Now, and they didn't get him until about a month or so later. That's when they first returned on to him, and he was back in Pennsylvania. So this is a very complicated, circumstantial case that the state could lose because the standard is beyond a reasonable doubt.
Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, your very own personal board-certified criminal defense lawyer. And today we're reacting to the updates in the Bryan Kohberger case. I'm coming to you with my pearl-handled pistol cufflinks with the aid of and direction of our content genius that you know as Michael Rivers, the man behind the plan, the man behind this channel completely. Okay, when you have a complex case like the Kohberger case, before you get to trial, there's usually a lot of issues, and we're going to discuss what those issues are. And with those issues, they have to be litigated in court. Some people want information, some people need information, some people don't want people to have information. There's all kinds of different things going on in this case. But before we get to the Kohberger update, this is brought to you by eSign.com. eSign.com is a very effective way to remotely do business. So, for example, if you are an 80-year-old grandma in my basement and you've got a wrap deal and you're doing Cheetos and you really want to get your grandma out of there because she's also maybe, doing meth or whatever, you got to get her out of there. How do you get her out of there? Well, you get her a record deal, a wrap deal. She's not going to leave, so the only way you can have her sign is e-sign. So whoever is inking this deal downloads the app. They get 3 free signatures a month, and they emailed over the agreement, and now Grandma's a rap star going to be appearing in Vegas and no longer is in my basement. Wow. But I use it all the time anyway, like if I need a power of attorney because the client's going to prison or just in jail, or if they just can't make it to the office and I need to have them sign a retainer agreement, or I need them to do medical releases, that kind of thing. eSign.com is a very effective way to remotely do business because if it's not eSign, no one signs. Now, so there's a few different things happening in the Kohberger case. First and foremost, the judge just issued a 30-some page ruling on an order for an in-camera review. Let's talk about a couple different things. What's an in-camera review? In-camera review is where one party doesn't want the other party to see something. And in this case, it's the investigative genetic genealogy. So the FBI in this case used a particular technique to get DNA off of a knife sheath that was found at the scene. There was blood on it, and they took the DNA off of it. Happened to be Kohberger's, right? But they didn't know it was Kohberger's at the time. So what they did was they used this investigative technique, this investigative genetic genealogy, and they were able to get some kind of match and figured out kind of possibly who this was. And they used that information to turn them on to Bryan Kohberger. They didn't use that information to get any warrants. They didn't, and they're not going to use it in trial. So it was just kind of something that the FBI used to push the ball down the hill. Now, the defense has filed a motion for the disclosure of that information. Now, the judge doesn't know anything about it. It's a matter of first impression. What that means is they've never dealt with this before in Idaho. And I can honestly say in 26 years, I've never had to deal with this issue either. It's a fairly novel technique, but it's very effective. But prosecution does not want to cough it up. And so when that happens, the judge issues an order, and the judge is not sure yet if this is going to be favorable to the defense or not. There's also a case called Brady versus Maryland. Anything favorable to the defense, the prosecution has to turn over. And the judge says even if it isn't favorable to the defense, they still may be entitled to it. And why is that? It's because you want to go overboard. The law favors disclosure to the defense. But so what is he going to do? So he's ordered an in-camera review. An in-camera review means that he takes all the material in, and he is able to review it all in camera without disclosing it to anybody else, and it's not public yet, obviously. And then he'll determine whether or not it gets disclosed to the defense. My guess is he's probably going to disclose at least some of this information to the defense, because it is important to show how they got turned on to Bryan Kohberger to begin with. Because guess what? If that process is at all flawed, then the defense argument is going to be that the rest of it's flawed. So that's issue number one. I'm going to show you what the hearing before the judge, but remember what he did, or what he's alleged to have done. Bryan Kohberger is alleged to, in the early morning hours, go to this home, and he had some kind of prior interaction with one of the females in the house, but go to this home and stab 4 individuals to death. So he's charged with 4 counts of murder in the first degree.
In the order addressing IgG DNA. I also understand that the state and the defense have different lists. So I will look at it and I'll muddle through it as best I can.
Essentially what the judge is going to do is he's going to sift through all the IgG DNA stuff. And that's arduous, because it's very technical, and that's why he said the best I can, because he's not a DNA expert at all. And he may ask for guidance from the parties at some point. He may call them back into court, and I mean, he can't just call one party and ask for information. But one of the things that he's going to do is look through this to see if there's any confidential information that's not relevant, and go from there. Now, the other thing that is going on is the FBI has gone back to the scene of the crime, and they've done additional testing. And one of the things that the state wants to do is the state wants to present a 3D image and actually bring and do a walkthrough. Now, walkthroughs are kind of uncommon. You don't really see them a lot, but when you have a multiple homicide where you wanted the spatial distance between the rooms, and because you have one person charged with killing 4 people, and when you think about it, that's a big task for one person to do all of that. It seems difficult, if not impossible. So the state's going to want to have some kind of 3D model to show this is how it could have happened. Now, is some of that speculation? They're going to take information from the scene, and they do what they call LiDAR. It's a type of 3D mapping. And so they're going to go through and map out the house so they can show in a 3D image on a screen what their theory of the case is, how this happened. I don't like that in a way, because it seems like speculation, but what they're going to do is they're going to say, well, this is the reasonable inference drawn from the evidence. And it's going to show who was killed, when, where, and how. That's what they're going to try to do with 2 things. 1, a walkthrough, and number 2, a 3D image with probably animation, I'm guessing.
This is the type of stuff that the FBI, frankly, was created for, is to give that level of expertise that local law enforcement just doesn't have or access to.
FBI agents are headed back to the scene of the crime in the University of Idaho murders.
They're going to take one last crack at this, so to speak.
The judge has ordered that they have DNA evidence into the court by December 1st. I'm not sure if that's their trial date, but they're going to start trial soon. The other thing that the judge ruled on is the cameras in the courtroom. This will be a televised hearing. He said, I haven't put a decision out yet, but what I'm going to do is take control of the cameras in the courtroom. I'm not going to ban cameras in the courtroom, but I need to have more control over the cameras, what the cameras are doing, and what media or people who are not media are doing with the filming. So he wants to make sure that anything that's not on the record is not filmed. He also wants to make sure that the cameras don't unnecessarily and unduly focus on the defendant and the defense team, because he doesn't want to capture like notes of the lawyers or the defendant, for that matter, on camera. And you can understand that. I mean, if those are client and attorney communications, those are 100% confidential, and they shouldn't be on camera.
Telling me that other places in the state are giving a different instruction, that it should be beyond a reasonable doubt?
What I'm telling you, Ford, is that it appears that up until 1980.
So here's the judge basically ruling, or just before he rules, kind of telling his thoughts about cameras in the courtroom.
I'm sure you're probably interested in this. I haven't put a decision out yet, but what I'm going to do is take control of the cameras in the courtroom. I'm not going to ban cameras in the courtroom, but I need to have more control over what the cameras are doing and what media or people who are not media are doing with the filming. I know I can only control so much, and that's why I continue to urge people to be patient and have some dignity and some restraint.
So you can see that what the judge is concerned with. The defendant has a right to have a Sixth Amendment right and a 14th Amendment right to have a fair trial, and you want that fair trial. You don't want anything negative to happen to the defendant in that trial, because if he's convicted and you believed in the conviction, you want it to stand, because you don't want to have to come back and try this case again if you're the prosecutor. So when you look at the Kohberger case, in a nutshell, it's a very circumstantial case. They have some DNA, but they don't have their blood in his car. They don't have a whole lot of other things. And they didn't get him until about a month or so later. That's when they first returned on to him, and he was back in Pennsylvania. So this is a very complicated, circumstantial case that the state could lose, because the standard is beyond a reasonable doubt. So we're going to continue to follow the Kohberger case. This is just an update so you can see what the issues are. They're fighting about evidence, they're fighting about cameras in the courtroom, and they're fighting about, I don't know if they're fighting about cameras in the courtroom necessarily, but they're also fighting about this 3D imaging and walkthrough that the defense does not want them to do. Now, on the walkthrough, you'll see that the home is probably empty and looks nothing like it did before. But the value from the state's perspective is going to be that it shows the spatial distance between the rooms. And that way you can get a better handle as a juror how this task was completed according to the state. So we'll see you next time here on Criminal Lawyer Reacts. We are following the Kohberger case just like you would. And make sure you subscribe. Follow us on Instagram. Follow us on Twitter. Make sure you sign up for Patreon. And we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please, is that my God.